Hello, everyone. Are we on? I think so. Anyway, let me start in Portuguese, just one line, and then I'll go into English, okay?
Sure.
Boa tarde, todo mundo. Sejam todos muito bem-vindos a mais uma edição do nosso Chá da Tarde com a professora Carole Basri. É um prazer imenso recebê-los aqui. Nós temos uma sala com o nosso intérprete, o Thomas Campos. É só entrar na sala dele, apertando aqui o botãozinho abaixo, onde aparece Interpretation. Lá, o Thomas vai, então, fazer a tradução simultânea de tudo que a gente falar aqui. Coitado, desde já, parabéns, Thomas, porque se a gente enrolar muito, enfim, você inventa aí também, por favor. Brincadeiras à parte. É um prazer imenso tê-los aqui e o nosso programa é feito trimestralmente com a professora Carole Basri. Professora Basri é uma querida amiga, primeira pessoa que eu conheci que falava de compliance algumas décadas antes, a gente não fala quantas, porque aí demonstra realmente a nossa idade, mas eu ouvi ela lá nos Estados Unidos, quando eu morava lá, falar de compliance, falando, mas que será que ela está falando? Mas ela já era a papisa do compliance, e por isso ela dava aulas na NYU, professor at NYU. Bear with me, Carole, okay? I'm giving
I am.
little bit of a bio of you, which it could be 3 hours. So,
Thank you.
Estava falando que ela já era uma advogada de sucesso, trabalhava no McKinsey, depois ela foi para Deloitte e foi uma das primeiras pessoas a implementar compliance, depois professora da NYU e depois da Fordham. Na Fordham, a Carole iniciou o primeiro programa de LLM de mestrado de compliance. E lá ela realmente foi um sucesso, foi a primeira faculdade do mundo a ter mestrado de compliance. E nós tivemos muita sorte, porque ela começou a vir ao Brasil e dar workshops especiais aqui. Eu sei que muita gente que está inscrita já teve aulas com a Carole, e nós, infelizmente, tivemos que parar durante a pandemia, mas como a gente nunca para, we are unstoppable, right, Carole?
Yeah.
A gente faz esses Tea with Professor Carole Basri. E o nosso moderador é sempre um homem. Por quê? Porque a gente faz Breakfast with Tom Fox, que as moderadoras são sempre mulheres. Então, é por isso que a gente trouxe o Flávio Macias, que é um querido frequentador de todos os nossos eventos no escritório, e trabalhei junto com ele quando ele estava na Bosch, depois ele pode falar um pouco sobre isso. Ele é advogado também formado pela São Francisco, e hoje em dia ele é o Regional Compliance Officer e Regional General Counsel South America at ThyssenKrupp. E é mega expert em compliance com empresas alemãs. É realmente muito interessante, depois você chega nesse ponto também, porque tem aspectos muito interessantes de compliance germânico. Então, falando tudo isso, só tenho que convidá-los também para a nossa mesa redonda, que vai ser na próxima terça-feira, e fora isso, teremos um outro programa muito, muito legal, para os nossos clientes do mercado de luxo, que vai ser no dia 24 de agosto, é um café da manhã presencial com o coordenador do COAF, o Henrique, vai vir a São Paulo só para falar conosco, e eu e a Maíra Martella da Deloitte vamos ser as moderadoras. I'm sorry, I could spend hours talking about these events, but I just wanted you to know that we have these very exciting events coming up. So without further ado, let me introduce you to Carole. Carol just say hello, Flavia will say hello, and then we will start.
Hello, and thank you for inviting me, Isabel. It's always an honor to be working with you, and I'm so happy to be doing this with Flavia.
Yes, Flavia, say hello, and then.
Hello, guys. Hello, guys. It is not only a pleasure, but an honor to be invited to be the moderator of this webinar, because I look up very much to both of you, to Carol and to Isabel. So it's no secret. And so this is truly an honor to be here and to participate and to support you with this webinar. Thank you very much.
Thank
Wonderful.
you.
Thank you. Well, as usual, the way we start this is Professor Basri always gives us the latest on anti-corruption movement, legislation, activities, cases, and also AML, which is one of her expertise, money laundering. So she will go for about 10 to 15 minutes talking about these updates. And then we ask you all to send us questions through the Q&A, I'm sorry, the chat. And then we'll pick up questions, Flavio will, and then ask Professor Basri directly the questions, sometimes combining them, putting them together, or putting them, if you can go on with questions in Portuguese, and Flávio will obviously translate them into English. Please do ask any questions. Don't be shy. Professor Basri loves the questions, and Flávio will make sure that they are translated to her. So ask questions at any time, but only do a favor. Put your name and the company you work with, or if you're not working at any company, you're lucky to have some time off, even better. You will have to ask 3 questions and not only 1, okay? Carol, please, what are the latest developments?
Well, the latest developments is we're really looking at culture lately. Culture's become very important. And we have the Boeing case and Google. And we've already talked a little bit about that the last time, but I think it's worth a mention. And I'm going to ask Isabel to comment also, because I think she was doing an article on Google. But I think these are 2 really important things, because we're looking now at the culture of companies. And what's happening is we're being asked to not only audit in step 5. So you do a legal risk assessment, and then you have 7 steps for an effective compliance program. Step 5 is auditing, monitoring, testing, and surveillance. And what's happened now with culture is that regulators are asking that you audit your culture. This is not an easy thing to do, but it's kind of a smell test. So you can look at it, but if you see that there's a culture that seems to be falling apart regularly, and that's what happened with the merger between Boeing and Lockheed. Boeing had always been, they were called Boy Scouts, actually, and Lockheed was called a hunter-predator. And the difference was that they had different ways of looking at things. A memo had to be written in 15 minutes or less, and it needed to take 5 minutes or less to read. So you can imagine there was a real emphasis on doing things fast turnaround and not looking into the deep issues. Now, if you have deep issues, as Boeing was having with 2 of its planes that crashed, that culture then, after several years, begins to show on safety issues, quality issues, and it also creates an environment where engineers, though they are brief, I mean, they're not like lawyers where they write tombs, do need a certain level of time to express themselves about what the issues they're seeing. And they felt that they couldn't really express themselves in this culture. Similarly, and please comment on this, Isabel, Google got into really trying to work with attorney-client privilege. And we all know how important that is. And I would suggest, just before we get started, that everybody is giving seminars. It doesn't have to be long. It could be 20 minutes long, but all employees should know a little bit about attorney-client privilege, just so that they don't press a button and say CC and send it to everyone, because then the information that they got from the attorney is no longer privileged. You've distributed it beyond the circle of people who need to know. And that's very important. Once you do that, it means you're making it public in a sense. And once you do that, it can come into a court case and the privilege won't be recognized. So it's very, very important that you look at privilege carefully and that you tell people who are executive management, board of directors, and indeed every employee, something about attorney-client privilege. What are the hallmarks of attorney-client privilege? Are you living in a civil code or common law country? Because if you're in, a common law country, then what can happen is that the attorney-client privilege is for most in-house counsel, except India. In India, the in-house counsel don't have attorney-client privilege, even though it's common law. And in civil code countries, except for Germany, Spain, and and Brazil. We're in Brazil. Here we are in Brazil. That's why it didn't come out. I said Brazil first. Germany and Spain, in-house counsel do have the attorney-client privilege, and Isabel is the expert in the world on this for in-house counsel. And she has chapter 2 in one of my books, International Corporate Practice. It is amazing. There's nobody. Lex Mundi doesn't come close, because what she does is she explains the difference between the privileges. So in a common law country, the client legal privilege is owned by the state. It's sacrosanct. It's under the duty of loyalty to the state. In a common law country, it's owned by the client, and the client can even waive it. Very different. And it has very different results. Anyway, Google was telling their employees in their seminars how to do memos so they would be attorney-client privilege. Make sure you CC the attorney, and it will be attorney-client privilege. This was in a common law area. And the attorneys were not responding. They were just on there so that the business agenda could be kept confidential. And in fact, this happened in thousands of emails. And the judge in the case was very, very upset to see it, but more so the Justice Department. And they wrote a compelling argument on it. We'll see what the judge actually does. But it has made headlines within the in-house community in common law countries, particularly in the US. You don't want to abuse the attorney-client privilege by marking documents. So they had set up these guidelines on how to do it. And they wanted things to be attorney-client privilege that were really business. And they wanted things to be attorney-client privilege that really the attorney never responded to. It was just CC'd. The dialogue was to protect the dialogue between business people. So do you have something to add on that, Isabel?
Oh, yes. Actually, just want to say one word very quickly, because I don't want to interrupt the updates. Here in Brazil, we're civil law, as you mentioned, so we have the professional duty of secret guaranteed by law, by the
right.
Code of Conduct of the Lawyers, OAB. However, I see here in Brazil that every time lawyers talk to other countries, they sometimes, and this is not intentionally, Carol, put attorney-client privilege for absolutely everything.
Yes.
Is not the case, because attorney-client privilege only applies to the communications that really can be used in the future to protect the company. It's a long subject, so I'm not going to get into. right now because of time, of course. But
Sure.
the fact is that because Google did that, quote unquote, abused it, I am telling the President Fellows here to be careful with labeling everything attorney-client.
Yes.
Because in fact, here in Brazil, you almost don't have to worry so much about it because it's guaranteed by law. It's always a good, any email or communication you send, always say confidencial, sujeito ao sigilo profissional, confidential, and sort of the equivalent of attorney-client privilege in Portuguese. But, you know, I do now have my concerns because of this Google case.
Correct.
And the judge there, the court decides, then everyone's going to be in trouble, not only Google. So that's my take on this. And I wanted to emphasize, because Tatiana just mentioned to me that your questions should go to the chat, and Flávio and I will pick them up. Flávio mainly. So do have your questions there in the chat about any subject. Professor Basri is here to answer on anything, right? But culture is extremely important because it's a big component of ESG nowadays.
Correct.
Right? So
Right.
Go ahead, Professor.
Well, that brings us to ESG. Now, environmental, social, and governance. So what I have been telling people, and I really believe this, is we all should be worried about the environment. We all live here. It's not an issue of climate change or not climate change. It's an issue of what's the right thing to do in the climate. And you don't want to do something to our beautiful world. We want to preserve that. So that's how I would look at it. This should not be a controversial issue. It should be one where we're just talking about what is the right thing to do in terms of the environment. But you have to balance that with other concerns. If people are going to be losing jobs, if the way you do it creates more environmental problems. And I find that sometimes happens. So again, I think it's good now to think about this issue. But what if you're in an office, for example? Your business is in an office, you're a service industry, you're an accounting firm, you're a law firm, you're giving advice, whatever. You still have to worry about the cleanliness of the air in the office, the environment you're in. So just think about that as a work safety issue, because people are now asking those questions of all businesses. Sometimes things get out of hand. So we're not just talking about mining companies and lumber companies. You should all be looking at the quality of your environment. Okay, would you agree with that, Isabel? And that's something that I was just at a very big conference, and people were asking the audience, does this affect us? And the answer from everybody on the stage was yes, because we all live in an environment and we should all be conscious. That's part of ESG. Now, I also wanted to say social issues are the S. Modern Slavery Act, social issue, employment practices, diversity, equity, all these things are under discrimination, are under the S, social, okay? And for some, it's much broader than for others. For example, if you're a mining company, how you treat your workers, that's an S, very important. And I would say that we should all be very aware of the corporate social responsibility, which was the precursor to this, and sustainability, which was also a precursor, and then the green movement, because those are still in the ESs, environmental, green, corporate social responsibility somewhat, sustainability definitely, and with the S, again, sustainability, corporate social responsibility, all are under that S. And so we have to go back to basics. Before there was even corporate social responsibility, we were talking about the UN, and we had no slave, prison, or child labor. If you're doing any of those things, those are bedrock not to do. And they could be in your supply chain. So be very, very aware of that. Go back to basics because we're still defining what the S means in social. We don't have a clear handle on it, but I know that it's going to include slave, prison, and child labor. I also know that the Modern Slavery Act is an expansion of those thoughts. I also know that there are countries we know about. I also know there are more slaves now than at any time in the world. So this is a very sad commentary on where we are. And again, we're right at the bottom of this whole thing. So when you're evaluating yourself, I always say, take a very strict view to create the baseline, and then you can show how you're improving on that. Particularly if you're in the mining industry, I think also in any kind of manufacturing industry, particularly if you manufacture offshore, from whatever country you're in. If you're manufacturing offshore, it makes it harder for you to know what's happening in the factories, but that doesn't lessen your burden and responsibility to know what's going on in those factories. So I find this to be very important. And as an attorney with ethical obligations as a member of the bar in common law countries, or even that you're not part of the bar, but in some countries that are civil code, but you still have a responsibility to provide ethical guidance. And I believe that this is one place that you really should speak out, be very aware of what's happening, not only for your company, but for the supply chain. These are some of the most egregious places. The other thing is the governance. Now, this brings us into the Caremark decision. Personal liability for the compliance program for the board of directors. Why does it bring us into that? Why am I talking about that? Because this was always considered the one thing that was the hardest to prove, that you had personal liability for oversight of the compliance program. Now, I'm going to go back to basics again, because I think it's so important. But if you're on a board, you have a duty of care and a duty of loyalty. The duty of care has two parts to it. Duty of care in decision-making, okay? And that's, you get the business judgment rule to protect you as a shield. And there's a duty of care in oversight of the functions of the company. What does that mean? Well, it applies to compliance, but it applies to everything in the company. You have oversight as the board of directors. You can't shirk that responsibility. And there have been a number of cases. Now, I'm going to use Delaware cases, but there's a number of cases in the last 3 or 4 years that have just come out. Mershond is one of them, but I'm not going to go through all the names for you because, again, you're in Brazil. But similar things are going on internationally, where they're saying now we can make a Caremark claim and we can go to court and look at this because there's enough evidence, and the bar of best practice has come down since the Caremark decision, which was in 1996 at the Delaware Chancery Courts. That bar has been raised, okay? And what you need has come down to prove that claim. That's what I mean. So we've raised up what it means, and it takes much less evidence, to make a claim that the court will look at. So, for example, there have been cases where boards of directors had not known anything about the subsidiary and what their practices were, except that they were making money. That's not acceptable. You have to have those reports. You have to have oversight for compliance to know what they're doing. Yes.
Carol, may I ask the first question? Our participants are a little bit shy, so I will start with the questions to see
Sure.
if I motivate them. In Germany, next January, the Supply Chain Due Diligence Act will come into force. So, yes. Which is very tied to ESG practices. So the companies do have the responsibility of monitoring and making due diligence throughout their supply chain. So to prevent modern slavery and to assure governance and to prevent damage to the environment. So all the topics that you have been covering. Do you understand that these decisions that you just mentioned from Delaware are the equivalent in the common law to this movement that we are seeing in Germany with the Supply Chain Due Diligence Act?
And this is such a good point, Flavio. Thank you, because this is a worldwide movement. Okay, it's happening in pockets. Places like Germany, the UK are getting involved, and many of these laws are going to be long arm statutes, just like FCPA. I don't know if you agree with me, and I don't know exactly what's in German, but they're going to be long arm. So your supply chain starts in China or Indonesia, and they're going to ask you or India, who is making these products? Under what conditions? Are we under the Modern Slavery Act, which, by the way, is long arm? So there's due diligence on that supply chain, very important. And we're going to be asked those questions, but also in some of these countries, for example, you're in Vietnam, the local courts are going to be asking the same questions. So you should look at it both ways. The fire in Bangladesh, we all know about that fire that occurred several years ago in the manufacturing and killed so many people. And I'm trying to remember the name of the building, but it was horrific fire. The local laws also came into effect. They had to answer to their own people, as well as the consumers in the global markets in, the US or Germany, or even in Brazil. People wanted to know how things are manufactured.
Definitely.
And things have changed. So I think that's a very good point. And it also goes back to compliance. Step 3 of the 7 steps for an effective program is background checks. So the first thing we do is a risk assessment. This is definitely a risk. Your supply chain is definitely a legal risk, because there are legal requirements about fulfilling times, who's in the supply chain, everything. So there's a legal component. It's not just operational. Then there is number 1, policies, procedures, and internal control. When you're doing supply chain and looking at it for legal risk, okay, then you need to put in policies, procedures, and internal controls. So it's not just saying that we're going to do due diligence. We expect controls on it. Controls can be third parties going into the factories, third parties looking at who is actually doing the shipping. Are you paying people that are getting below minimum wage and children to do this? Or are you doing it, the proper way? Are the ships properly insured? Do they have proper facilities for the crew? And then when they're offloaded, what happens there? And is there safety issues, or is there rodent control if you're taking food? You have to look at all those controls along the way. Next is making sure there's somebody in charge. Now, because it's supply chain, frequently it's left off the decision-making, saying that's not a legal risk, but there are parts of supply chain that are legal risk. It should be covered by the compliance department. And if you're a big company, you should have dedicated staff just for supply chain compliance. Number 3 is background searches. Background searches does not mean you just background search your employees, executive management, and the board. It means now that you do background searches, which are much, much more detailed. And you can go and look at whatever you want on the internet. There's nothing you're not allowed to look at and prohibited when you're have a vendor, an agent, or a supplier. Okay, nothing's off limits. You can go and look. I mean, you can't, illegally spy on them, but pretty much you can do all that investigative work, and you should, because people have patterns and companies have patterns. And if something is wrong, you're going to see a pattern. So background searches not only means looking at all that, Business Bureau and everything, but also talking to other clients or people that have used these agents. And really be logical. If you do all of this and there's a problem, the government will think you're a hero for doing all this. And they'll say the only way it happened is a rogue employee that, you know, engineered it probably. So that's good. Now, the next thing is training. A lot of us give a lot of training to our employees, particularly in our headquarters. Make sure you also train people in subsidiaries and far-flung locations, but also start to train your suppliers, vendors, and vendors, suppliers, and agents. Also make sure that part of that training includes, number one was policy, procedures, and internal controls. You should have a code of conduct for your suppliers, vendors, and agents. And you need to train on it, because we all know that a code of conduct is useful if there's useless if there's no training. It's just window dressing, it's a sham. And then we want to make sure that we have step 5, auditing, monitoring, testing, and reporting. And we've just talked about how important it is to test the system, to know what's going on, and audit for all these things under you know, Modern Slavery Act or whatever could be going on with the supplier. You want to do auditing, monitoring, testing. You may want to even get third parties involved, because it's very hard to go into some of these countries not knowing the language and have them take out 1 or 2 people from the line who are going to say whatever you tell them to say, because they don't want to lose their job, which they're getting paid very little for. So again, you really need to be able to take aside people in a non-threatening environment. That's a very tall order. And so a lot of investigative work needs to be done with auditing, monitoring, testing, and reporting. And then incentives and discipline. Discipline your suppliers and vendors and agents when they do something wrong in the supply chain. Let people know what happened. Don't just keep it quiet because there's a pattern. You want other people to know about the pattern. You also may want to go to prosecutors, because then they know that you're very serious about your supply chain working properly and upholding the values of your company. And then you'll be seen to have values, by the way. And then constantly update this process, because you have somebody in charge or a group in charge, and also have internal investigation protocols for how to deal with your suppliers, for example. So I think the due diligence that you're talking about in Germany is very important, but not if you don't frame it in the risk assessment and the 7 steps. You've got to do that. Otherwise, due diligence is a meaningless term. What is due diligence?
In other words, just circulating a supplier code of conduct to your supplier just won't do anymore, which is with what a lot of companies do. And getting, as we still have no questions, I'll start singing, guys. Please ask some questions. If I'm joking, I will not sing. Continuing on this topic, Carole, you mentioned about the risk. You mentioned that part of the risk is compliance risk, is legal risk, but there is other risk aspects or other risk areas. And then when we were briefly discussing before the webinar, you brought up the risk officer figure, which is something that is this figure is this a new trend? Is this figure how can I say motivated or put by the ESG trend? How do we see this risk officer? What are the challenges? What is this new position that we are seeing in the companies in the States?
Well, we're not just seeing it in the States, actually, we're seeing it globally. The States is not ahead of the curve on this. I found more of these people in global companies that are not based in the US. The US seems to be fairly parochial about having a general counsel, compliance officer, and an enterprise risk management person. But what I'm seeing globally is that for the really large companies that are really the big players, they want somebody who can be in control of all of these risk areas, including ESG. And they want one point of contact for the board and the executive management and the CEO. And I think this is a trend we're going to see much, much more. And this figure is going to be somebody who is very trusted. I think it should be somebody with a legal background as a lawyer, but that is used to dealing with crisis management, operational risk, all the things that are in crisis, force majeure, acts of God, as well as the operational risks, and that it crosses platforms. So where lawyers are just looking at legal risk and compliance officers are looking at the law to comply with the law, the chief risk officer has to take it across, because there are many things that have implications that go beyond the law. For example, financial reporting is legally required for global companies. However, if you isolate it to just legal issues, you may be missing the point. The point may be that the entire structure of the company has financial issues that have not been leveraged by insurance or other things, and that are not legal issues, they're risk issues that have come into the financial. Some companies, just like some people, have a larger appetite for risk. Now, when does that become a crisis? Well, we all know you have no more money left, or you have very little money, or you don't have credit. All these things can happen to a company. And particularly if we look at Basel I and II for banks and things like that, that's exactly the problem. Are they too big to fail? Can we make a company insulate it so it doesn't fail because it's so critical that we want to make sure we're not going through another great recession like we did in 2008, 2009. So again, I think this is a great question, Flavio. Thank you. But I really think this chief risk officer is somebody that has, kind of background that you have, because I've been talking to Isabel. It has to be somebody that knows how to work on the global stage, because there are only global companies that are doing this right now. It has to be somebody that's a lawyer, but has a good sense of business and operations, and also somebody that works well with other people, because people try to silo their risks, hide them under something, hide them in that silo so that they don't get out. It could be a subsidiary that doesn't want it to go out, or a business unit that doesn't want it to go further to the top. So they can try to fix it. And the way they fix it is usually doing something that's not quite right. Maybe even a cover-up, maybe even illegal.
Perfect.
So,
thank you, Carole. Thank you for that. Yes, we have the first question in the chat, in the Q&A. Great. It comes from Fernanda Stephanie Correa. She didn't identify the company, but nevertheless, thank you, Fernanda. And her question is, what about business human rights? Does it fit in the ESG, or it needs to be taken care as a separate subject?
No, it fits under social. And it clearly, to me, fits under social, because business human rights is, how do you treat the people that do the work for your company? Are they slaves? Are they employees, but they're not given safety and health protection? Are you abusing the people? Are you creating a company like, let's say, an Uber or a Lyft that may create situations where people can get into those cars and hurt the drivers? That would be a problem. And we've seen that. Have we done the background searches on the employees? But do we also have a way for a driver to hit a button and call the police because a gun is being shown to him or her? I mean, these are business human rights issues. What if you're very good to your employees and there's no harassment or bullying in your company, but then you send a young man or woman out to deal with a supplier and you say, get the job any way you can, and they are forced into a difficult sexual situation? They're still on the job working. That's a human rights issue. And you as the employer have to be able, if they point that out to you, and you have to make an open door policy so they can, you have to be able to then go to that supplier, vendor, or agent and say, you cannot treat our employees this way. A, you're going to be reported to the authorities. B, you will no longer have our business. And it has to be a zero tolerance, because you're putting people in such a difficult situation. For them to have come forward is almost heroic. I mean, very few people want to be the one who says we can't work with these people, even though, you know, we got good prices for them, or we need the business. It's heroic to come out. But this is going to be happening more and more as we go more and more remote. So a lot of these issues also have to do with how the landscape has changed. What if we discover that those suppliers, vendors, agents have a disease, COVID, monkeypox, and they've not isolated, they've not taken temperatures, and that's the guidance within the health authorities that they should, and you're putting your employees in jeopardy. That's a human rights violation.
Indeed.
And we all know of situations like that. What if we put them in a situation where there's going to be a party with a lot of liquor, and you're going to have people who act out? Are you going to have people there to take care of that? Or are we just not going to have those kinds of events? How are we going to deal with that? It's a very difficult thing, and it's very cultural also. So I think that was a great, I think that was a great question, because I think that's under ESG. Sorry, my hand. I think that's an ESG issue. And I think all of us need to be concerned about what social means. If you remember when I first mentioned ESG with Isabel, I said the S hasn't really been defined. And that's why this is such a good question, because our business human rights in there, yes. And they extend beyond just the people that are employed in that business. It extends further than that to human rights violations. So I would think that that's just the tip of the iceberg. We're going to learn so much about social now, just as we've learned about the environment in the last few years. This is going to be a very big issue. And governance is very, very important to this equation, because governance is going to have to oversee it. And they're going to keep having more and more personal liability, because the trends I talked to about Caremark are trends that are existing across the world. Personal liability. You want to be a director, you want to go 4 times a year to a board meeting, and you want to collect $100,000. That is not what's going to happen anymore.
Indeed, indeed.
Yes,
Thanks, Carole.
when you say you want to collect, I remember that we have been seeing cases where the compensations to the CEO are like 1 million times more than the compensations to some of the officers, and that
Correct.
A social question. But Flávio, go ahead. You were going to say something.
No.
Right.
This is a topic.
Question.
Yeah. This is a social question. This is something that is also checked under ESG. The difference in between the CEO, the ones that makes the most, that collects the most within the company, and the bottom employee, the ones on the tip of the line. So yeah, this is a super interesting topic.
Super interesting. And that executive compensation issue, because right now, for example, in the US, executive compensation for the top 30 people, I believe, have to be reported, and it's public knowledge. So now we have the laws that at least give you an idea of how much compensation executives are getting, okay? But before, we didn't even have that. It wasn't reported for public knowledge. Now we have that. Now I think we're going to see people looking at that disparity. And also, you're going to look at clawbacks on executive bonuses and compensation. Things have changed in the world.
Right.
Yep. And I think that the next question, which is which was asked by Mauricio Davila in the chat. Again, not
So
sure
I audit. I
audit.
I like a lot, have done a lot of work with I audit. Yes.
Okay, Mauricio from I audit. His question is to Carole. What do you think about companies that are only worried with yours interests and are only doing greenwashing for ESG questions? So the ones who are doing greenwashing to rate or to reach the ESG targets.
Well, and you know, I want to add to that question, Carol. You know,
Yes.
this is obviously not a crime or not a wrongdoing. I don't know, but how could they be sanctioned for greenwashing?
Well, you know what? I'm going to
Right?
say controversial. I'm happy there's greenwashing because that means that people have the idea that it's important to do something about the environment. I mean, at least it creates a baseline that you should at least greenwash. And I think that's important because I don't think if you talk 10 or 20 years ago, environmental was really on anybody's radar screen except, you know, mines or lumber companies and things like that. I think this has completely changed. You know, the Kyoto Accords, I think were the beginning of some of that. But now everybody thinks about what are they doing to the environment in the way that their product is produced or the way they give their services. This is now, if that leads to greenwashing, well, I remember when compliance started, people were lauded for endowing seats in law schools and colleges on ethics. Okay. And the judges were okaying that. So the fact that you're doing something shows you at least are getting
One step at least, right? It's better
right.
than nothing.
And what I find
you're
in the
concerned
law,
about it.
right. What I find in the law is that if you go to the executive who wants to quote unquote greenwash and tell him don't do it, then he thinks he doesn't have to do anything. He doesn't go to doing more, he goes to doing less. So what I think is that what we have is when the water rises to do the right thing, a best practice, all ships go up. And I think if everybody's greenwashing, people will start doing not greenwashing, but the right thing. So for a long time, I would tell companies, and as I started, and you know this, just do the 7 steps and the risk assessment, have something there. And that will encourage you then to give each of those steps and the risk assessment the appropriate amount of time to do it right. But you can't run before you walk. So ESG is in the walk stage. I want to emphasize that. That doesn't mean that if you're a big environmental company, you can get away, you know, that, for example, lumber or mining or something, you can get away with environmental pollution or anything like that. But what I'm saying is for all the companies out there, you've got to have something going on, and a lot don't. I don't know if you agree with me.
It's going to be a reputational risk.
Yes.
Companies to then, you know, the consumers discover, they find out that they were actually lying and somehow we're defrauding people, right? So I think that the companies will start thinking about that. But
Right,
definitely,
I wanted to give you one more example. Fast food business, okay? If a fast food business is not taking care of its trash properly, that may or may not be considered an environmental problem. You know, they're not sorting or whatever, and it could be embarrassing, but not so embarrassing, right? But in the future, I think that even their greenwashing of having recycling bins and everything will lead them to eventually start to really do the recycling necessary globally. Okay. And then get to the point where they have plastic products that are not being, you know, just thrown in an ash can, but doing what is going on now with straws being paper. And I remembered paper bags from when I was young. Now we're going back to paper bags all over the world. And so, yeah, that could be greenwashing at the beginning, but you have to set the process and the culture in place. This can happen slowly if there's no governmental pressure, or faster with laws that outlaw plastic. But it'll happen one way or the other. And then enforcement. I see a lot of plastic that's not being enforced right now, but we will see it globally in the next few years.
Perfect.
So I don't know if that makes sense, but to me, I always try to look at the positive, because creating best practices that everybody follows creates societal change. And that's very important.
Yeah, I just think that I would just add, Carol, that the board of directors need to be mindful about the greenwashing, because they can be held liable for that. And in certain jurisdictions, they can be held liable for that, and that could even impact the companies and how the companies is viewed, the company's image to the public. So yeah, definitely we need to see it positively, but they also need to be mindful about the liabilities that are behind their greenwashing.
Absolutely, Flavio, I agree with you totally. But if you're talking about liabilities, that means there has to be a law that says don't do it and you'll be fined. And then it has to be enforced by the prosecutors and the judges, you know, and the legal system. What I'm talking about is the soft environmental things that we know are going on in companies that, unfortunately, they may try to greenwash, but at least they're trying to do something before there's law there. They're self-regulating, and I guess that's the distinction I'm making there. And I think that very often companies know more about their environmental sins than any prosecutor does, or any governmental official, or any legislator does to legislate. They know what they're doing, you know?
Definitely.
So I think we're saying the same thing.
Well, we're coming to the end, and I think—
Are we already?
I know, it goes so fast.
Wait, I have one thing I need to say.
Okay, but I was going to say, I think we have time, Flávio, for one more question.
Yeah, indeed. Let us first let Carol say it.
Okay.
I would as the last topic, I would propose that she make some comments regarding the deferred prosecution agreement and the new trends. Oh yeah, so that's jackpot.
Flavio, I really enjoy working with you. So,
and so yeah, I would ask for some comments on this new trend, which is super interesting from a compliance standpoint.
Exactly. So there was a recent DPA, and I can't give you exactly who was involved because I haven't been told. I've been looking for these names. Maybe somebody can find them. But it's a recent DPA from the Department of Justice in the USA. A DPA is a deferred prosecution agreement. So they made an agreement with a company that the CEO and the CCO, the Chief Compliance Officer, would sign off on the compliance program. That is a very major change. Now, that's just for the DPA. But I believe, and this goes on along with the Chief Risk Officer that you mentioned, Flavio, that just like in Sarbanes-Oxley, where the accounting firms were able to charge 50% more because they were reviewing it so the CEO could sign it because the CEO was scared to go to jail, and the CFO was scared to sign it because he was scared to go to jail, or she was scared to go to jail. We're going to see the same thing with the CEOs and the CCO, Chief Compliance Officers. And I would dare say that this should not be done by accounting firms. This should be reviewed by attorneys who know about risk assessment and compliance, because we're dealing with prosecutors, and we want to use the structure of the risk assessment in the 7 steps so that we have the defense that went on in the Morgan Stanley declination from prosecution in 2013. We want to show that we have an effective compliance program. Lisa Monaco has been very good about talking about that. So I'll leave it there, but I think this is a sea change, and I could see that within 3 years, they'll be signing by the CEO and the CCO every year to certify their compliance program.
That's okay. A good for the next one, Carol, because I think that Lisa, for those of you who don't know, Lisa is now the head, the boss at the DOJ, and she has been very stringent on the subject, and a lot is going to happen with the,
Right.
she going back to monitorship, and here in Brazil also the
Right.
latest decree regulating our Clean Company Act is decree 1129. Yes,
Don't look at me. I'm not good with numbers.
and I will remember the article, Article 52.
Bravo, bravo, Isabel.
It's probably in favor of monitoring here in Brazil. So that's a big subject in for our next tea with Professor Carole Basri. Unfortunately, we have only 1 minute, so I'm going to use that 1 minute, Flávio, to thank you as our special guest. Always wonderful to have you. Very active with our round tables, and his participation is always very good. You know, we really have our participants who are very active and outspoken, dear to our heart, and that's why we sometimes put them in the position of a talk show man, like we're doing right now. Thank you so much, Flávio. Wonderful.
Thank you, Isabel. Thank you, Isabel. It was great to be here. The decree number is 11,129. I just checked in parallel. And it was a pleasure having this opportunity. Thank you very much for this, and you know, you can count on me whenever.
We'll invite you again soon. Don't worry. We'll put you on the spot. Carole, as usually, thank you so much. It's wonderful to have you. I'll see you soon. I'll be in New York very soon. So I just want to thank everyone. A nossa próxima mesa redonda vai ser no dia 9, na terça-feira, sempre nas terças-feiras, segunda terça-feira do mês. Vai ser ainda virtual. E o tema vai ser o tratamento de denúncias no canal de o canal de como se você chamar de denúncias.
De reporte. Canal de reporte.
Exatamente. O tratamento delas. E a outra, o outro programa que vai ser presencial, nós convidamos o coordenador do COAF para vir ao escritório, é um programa em conjunto com a Deloitte, e estamos promovendo o encontro do mercado de luxo com o COAF. E por quê? Porque o mercado de luxo está sujeito à lei que o obriga a comunicar certas transações diretamente para o COAF em 24 horas ou menos, porque as resoluções falam em assim que possível. E o mercado de luxo não é apenas joalheria, pode ser qualquer loja de roupas com mercadorias de alto custo, couro, bolsa, sapatos, carros de luxo podem ser, galerias, obras de arte, todos que podem, de uma certa maneira, lavar dinheiro. I'm talking about, Carole, AML. We're going to have a meeting with the COAF, our regulator here in Brazil, the luxury market. So we're going to have the jewelry.
Oh, wonderful. You'll tell me what happens. I'm very interested in that market.
It will not be virtual. It will be a real breakfast, something we love to do. So
lovely.
A lot of networking, and that will be on August 24th.
Great.
It will be the networking breakfast, 9 o'clock sharp. We start with COAF talking to Mercado de Luxo. So with that, I hate to end our program, Carole, but thank you so much. And again, Flávio, and everyone who came to this event, thank you for your participation. And
thanks, Isabel.
special
Thank you, Flavio. Thank you, Isabel.
Thanks, Carole.
Interpreter, and our marketing group that is always extremely efficient, Tatiana and her team. Goodbye.
Thank you, Tatiana.
Bye.
Bye, you guys.